Okay. So our CEO is hunting in South Dakota, I believe. He's away on vacation. Good for him.
He's the way the pipeline goes, that's good to know.
Yeah, that's what it is. I can see him doing that now. So we'll handle this ourselves. So relative to your application, we have from Drummond and Woodson, attorneys at law, Mr. Chenet, here to help us out. So I have a document which it's kind of a summary thing, and then I think there's probably a whole bunch of other, I haven't really looked at it yet.
You want me to
So,
I can summarize in 5 minutes.
please do.
Should I go to the,
Please do.
Actually, that's just for recording, so,
Can you pick me while I'm sitting here?
Well, sure.
Yeah.
So-
right there.
And
right.
please introduce yourself.
Yes. So, Rick Chenet from Drummond Woodson, and I represent Mr. Herman, John A. Herman, no period after the A. That's not a mistake if you happen to notice that.
Wow.
And Parrish Manson has been working on survey work on the property, and it's a fairly significantly large piece on the east side of Long Lake. And Mr. Herman and his sister, Mary Jane Rasabi, co-own it. Mr. Herman owns 3/4, and Ms. Rasabi owns 1/4. And they're in the process of splitting it into 2 parcels. They're gonna partition it. No development currently planned whatsoever. But for primarily tax-driven reasons, the division needs to end up such that they each get an equivalent in terms of value. So we've been working with Parrish, and we've been working with Mike McGuan, an appraiser in Waterville, to try to both survey the property and get a better handle on site conditions and the like, and to get an appraisal. So when Parrish was, and he can give a little more of the detail on what he found, but basically, when he got out there and did his topographical work, he determined that the slopes, particularly at the southerly end of the property, were such that your zoning map depicts the location of the slope, resource slope district essentially incorrectly, because the slopes are not, in fact, as steep where your plan suggests they would be. So we asked Parrish if he would pursue an amendment or a correction to that map. And it appeared to us and to Parrish that under section 10 of your zoning ordinance, your shoreline zoning ordinance, this was a situation in which the appeals board would have the final say as to the location of the lines on the property based on the actual sloping that Parrish has put together, is working to put together. And he had submitted plans that supported that. So I'm trying to find my letter here. Section 10 of your ordinance says, it's entitled Interpretation of District Boundaries. Unless otherwise set forth on the official shoreline zoning map, district boundary lines are property lines, the center lines of streets, roads, and rights-of-way, and the boundaries of the shoreline area as defined herein. Then it says, where uncertainty exists as to the exact location of the district boundary lines, the Board of Appeals shall be the final authority as to the location. So we assume that Parrish could go to the ZBA. I guess we started here, but we referred to the ZBA,
Yep.
anticipating that he would present topographical work on the property to show that in fact the line shown on your map should be shifted further away from the water because the slopes in that area aren't in excess of 20%, right? So I was not here at that initial meeting, but it got referred from you, as I understand it, to the CBA, but it never went to the ZBA. The chair of the ZBA decided that he would seek advice from Maine Municipal Association, which is fine. But MMA came back and said, no, we don't think that this is a situation where the ZBA can change the map based upon more specific information as the site conditions. Rather, it's essentially an amendment to the ordinance, which, as I understand it here, would go, I guess, come back to you for drafting of a appropriate amendment to the ordinance, back to the selectmen for approval, and we get on the vote, the warrant for the next town meeting. So we then went to the council, the selectmen, October 18th, and unfortunately, I had a hard time finding your office. I don't know how I could miss it, but I ended up at the, anyway. So I didn't catch the whole meeting, but I think the gist of the meeting was, there was discussion of this, and the selectmen referred it back to you, I guess, to discuss, one, process, and two, no matter how this gets addressed, some discussion about the possibility of adding language to your ordinance that would essentially say, when an applicant comes to the planning board for approval of a project, in that the applicant would present more specific site information to confirm things like slope. So we're here tonight. I'm not necessarily here to pound the table and argue about process. At this point, we just want to kind of understand whether we're going back to the ZBA or whether you're going to process this as an amendment to the ordinance. Again, we are not in the process of developing anything. I don't think Mr. Herman and Ms. Wasabi have any plans to develop anything. It's more a case of getting the right zoning situation on the property, because it factors directly into our effort to finish appraisal work and finish the partition. They may build something there in the future. I doubt it would be anything more than a summer camp. It's just, it's pretty tough land to get to the end. I don't know, did the board? We didn't get the board up.
Yes, they did.
So you've seen it, it's,
Oh, yeah.
I haven't, but
it's a
they have.
spectacular piece of property, but it's strewn with huge boulders
Yeah,
and some
I mean,
steep.
I didn't attend, but, the summation was it'd be tough to develop.
Yeah, I mean, at best, the cost of building a road to the far end, the plan is primarily, is essentially for Ms. Rasabi to get a parcel, a portion of the property at the north end, which is closer to the existing. They also have a family compound there that is now owned by their respective children in a limited liability company. This piece of Broadset, and then John would get the far end, where this slope issue problem exists. So that's fundamentally the situation. Paris, do you want to add anything to that?
No, not yet, no.
Okay.
I don't know how many amendments you've written for the shoreline zoning ordinance. I don't know what the process is. We do what we can to help, if that's how it's going to go. The part of the cause of the problem with the chairman of the zoning board of appeals was my inadvertent use of the wrong word. I should have said, per section 10, uncertainty exists. Okay, the language from the ordinance. What I said was, apply to the town for a redefinition of the limits of the slope district. And then the MMA lawyer carried that off to we were going to, I don't know, I guess he assumed we were going to ask you to remove the entire slope district or something, I don't know.
Yeah, it's not a change
No,
in use, it's just
Okay.
a more specific location of the portion of the property that has slopes greater than
The
20%.
The discussion with the selectmen did make it clear that if you are in fact going to work on an amendment, that you might want to be a little more sophisticated about it than simply writing an amendment that says, the town approves changing the slope district for Herman and Wasabi on Long Pond, and provide some more sophisticated method of taking care of these problems, because every slope district shown on your shoreland zoning map is subject to a reality check that's going to move things, okay?
Yep.
It may not make any difference, but it's going to move things.
And we're happy to, I mean, if you conclude that the best way to go about this is through the amendment of the ordinance and the town vote, I mean, I'm happy to help you out on drafting language and submit it to you so that you don't have to do it yourself.
Thank you.
Peter, you were at that meeting, the select board meeting as well, right?
Yes. Yep.
Is that your recollection as well?
Yep,
Because
that was
it was
my
unclear to me what, if any, direction really came from the select board to us.
We talked about a couple of things. One was,
Needless to say, they haven't talked to us.
yeah, I know, it's unfortunate that, you know, we haven't been able to meet in the same room to discuss this matter. But I was there, and I was able to answer some questions, both from some of the select board. And it seemed like the overall board had not understood at first that changing anything to do with the district on a map would be more than simple. I wanted to remind them that that is an involved thing, that it is the town authoritative source that we go to for making decisions, and that it requires things that are beyond some of our capabilities. For example, we don't have the software to update the shoreline zone map.
I see.
We use a service from, I believe it was Sewell, if I'm not
Sewell
mistaken.
Company, yeah.
Right.
And they, if I remember correctly, last time they were asked to update anything, they had trouble finding the appropriate ways to update such an outdated map.
In fact, we'd have to pay some kind of surcharge for rebooting up this old software and putting it on new GIS software.
If I can make a suggestion, what FEMA does with their flood maps is they make a note in their record, such and so property, letter of map amendment it's called. In other words, you submit data to FEMA and they say, no, that camp's not in the flood zone and you don't have to pay the outrageous flood insurance rates.
Right.
Okay. And then, when they publish a new map, down in one corner is a list of these suckers, okay? They don't change the map for each one. It would be insane to try and change the map for each one.
Right.
Because in fact, the next time you do a shoreline zoning map, you're not gonna use any of that stuff before.
Well, that raises an important pragmatic point, and one of my concerns about doing this by any means other than by changing the shoreline zoning map is, Belgrade is not that sophisticated as FEMA.
Nobody.
And we don't even have any professional staff, so it's all relying on institutional memory, and as these people change, that institutional memory goes away, and 5 years from now, your client comes back for a permit application, and if it isn't on the map, nobody's gonna know what was decided today or next month. That's the reality of it. So that would be one good reason to change the map, to reflect the change in where the 20% slope district is.
Right.
Because we've already gone through this with other situations. We just learned at our last meeting that the R's and S files for all our commercial developments have been lost in the course of moving from across the street to here. So that's where we're at in Belgrade. We've actually had permit applications, two that I can recall, one that I can recall in the resource protection slope district, and field verification to get, it was 20% slope and then some, probably, the entire lot. So
Could go either way.
we ended up denying the
Right.
permit.
Could go either way.
So, yeah, and we had another application where it was close, but not within that district. So I understand your point. I think that's I don't know what the right answer is. Frankly, these guys have been on the board longer than I have. I don't know how many times we've gotten applications on lots that fall into that resource protection district, but
I would say seldom to rare.
yeah.
Have we ever get
Well,
anything?
seeing as how we're going through this now, yeah, this is probably the first one.
Yeah, and, yeah.
Have there been any amendments to your map,
Um,
at the zoning map?
Over time, yes. But are they on a 4-year cycle? No.
On an as-needed basis.
Yeah, and then we're probably, I'll offer my opinion on this. I think we're probably catching up, even on an as-needed basis. It's like, oh yeah, we should probably get back to that, because, you know, we're all volunteers for these things, so.
Getting back to, the question number 1, which is, does section 10 apply or not? I don't know, and I don't know if anybody here knows what question Jay Bradshaw, the chair of the Board of Appeals, actually asked. All we have is the response from the MMA attorney.
Yeah, and I neglected to, his communications with Dick Llewellyn at MMA were by email, and I have them, but I didn't include that in my letter.
I have the response, but I don't have the actual question, I don't believe.
There you go.
Oh, no, I stand corrected, I do.
Yeah, he,
So where I'm going with this is, I mean, obviously your legal opinion is that section 10 applies. MMA, who's our attorney, represents the town of Belgrade, is of a different opinion. But we haven't had the privilege of talking to them. Only Jay Bradshaw has. And I don't know, Peter, how others feel, but if we're being asked to decide between whether section 10 applies or, which is the decision this board came to originally,
Yes.
versus the advice we've gotten from our own attorney, that it requires an amendment of the map. Consequently, the map is the ordinance, therefore the ordinance. I mean, I would want to have more communication with our own attorney about that and hear more of the justification and whether or not his opinion is at all altered upon, because he was CC'd on Mr. Chenet's opinion. So, I mean, I suspect there's some case law involved with this. I'm pretty sure there's at least one Supreme Court decision that's related. And I'd be surprised if there weren't some Superior Court decisions that are related to this, given the long history of shoreline zoning in this state. I know MMA is usually good at considering those, but there's no mention of them in their
Right.
opinion. I don't know if you've looked at those.
No.
May I? So, Mr. Bradshaw's letter to MMA says, however, as I read section 10, it clearly defines where district boundary lines are and states that where uncertainty exists, the Board of Appeals shall be the final authority. That's the language of the section. And Mr. Bradshaw says, since the request on behalf of the landowners is to redefine, not clarify an uncertainty, it appears that the path for making such a change is through an ordinance. Well, that's my language, redefine, okay? We had made no request to the appeals board, all right? He's using the documents that were submitted to you. I apologize for using the language of redefine, but in fact, what we were asking for was a determination of the location of uncertain slope district boundaries, and that was what you ruled on and said that should go on to the appeals board. I was told to wait until I heard from the appeals board, and I was dumb enough to listen to that advice. And before I ever got a chance to talk to the appeals board, Mr. Bradshaw had done this, okay? I have no problem with you guys talking to MMA, but when you do, we'd like to add here's what the other guys are saying.
Well, they have the benefit of your letter and your information already.
Who does?
MMA
I
does.
copied Dick Foreman,
Okay.
so he
Which
knows.
is good.
All
I'm
right.
sure he's very busy and he probably didn't have a chance to. Or I wasn't asking him to.
Yeah, right,
I
and,
sent it to
I,
him.
I do wanna bring up some maybe additional information that might be helpful and, regarding this particular thing. And this also comes back to the discussions held in front of the select board. Dick Bourne, who was a former chair of this planning board, had indicated that, he thinks there was some language in the current shoreline zone ordinance that could help, in this case. And he sent an email, which points us to he sent the email to me. And, he points us to section I, starting on page 77, which he says provides a means to allow development in RP and RP
do you have the ordinance?
shoreline zone.
One thing with it.
That's,
What page you want, Pete?
77.
yes, it does, but we're not asking for any development.
Yeah.
Understood. I just wanted to kind of get through what he was saying, just to see if the logic in that section could actually be used for non-development purposes, but just understanding where, within a lot, you would indicate that it is in resource protection or not. So he goes on to say, "Now, I'm not sufficiently clear on what the applicants are seeking and able to judge whether section I provides the precise relief they are seeking. The criteria for setting district boundaries anticipate on that survey inspection, a certain parcel within might have special exceptions to the conditions applicable to the district as a whole. The shoreline zone ordinance does anticipate that planning board review and update of the map is done on a 4-year cycle."
Right,
That's been
that's where you got that from, yeah.
Yep.
The second gentleman's shoe.
Oh.
Yeah, this, I'm reading this quickly, but this seems to set up a situation, or anticipate a situation where, notwithstanding a portion of the property's location in the resource protection slope district, if certain circumstances exist, you could get a special exception or a conditional use permit.
Right. So if, I'll just finish what Dick Bourne said. He said the 4-year cycle would provide a mechanism to address substantive reasons to change the district boundaries, but never anticipated that individual lots, and certainly not portions of individual lots, would be spot excluded from a district. So that's what he's kind of summarizing, and then points us to this section I, where, and you've looked through it briefly, and I just want to make sure we had a chance to look at it too. So, maybe by looking at this, there would be a way to review what you're asking and see if this applies to it. I don't know. Dick seems to think so. I thought there held some promise by looking at this.
Yeah, well, one problem is, what's already been mentioned, is there's no permit application before us for an actual construction project. So there's
True.
that, but I have to go back to, we're sort of in a catch-22, we being the planning board, in the sense that we rendered an opinion, you basically acted on that opinion, went to the Board of Appeals, or we're going to the Board of Appeals, but now we have the town's attorney advising the town, including us, that the proper course of action is to revise the map and consequently revise the ordinance. And it would seem to me it would be really imprudent on our part, without further discussion, to act differently than that at this point in time.
How would we start the process of writing the amendment?
That's a good question.
Because we're not changing the ordinance, we're changing the map,
But the map is incorporated into the ordinance,
right?
so.
So it's not a language thing that we're asking.
No,
to-
no,
So I just
but,
wanted to be clear with Parrish about that, we're not changing anything about, like, I'm gonna use the word definition, we're not redefining
I know,
anything about that, we're not changing anything about the applicability of the slope, you know, to anything. What we are asking for is where the precision measurements on a particular lot, or any lot for that matter, either do or do not meet the definition of what is a slope, resource protection slope.
there's a practical issue that's facing us here. And I can't remember if we mentioned this when you were here before, but we have plans to revise the ordinance, as soon as we finish the commercial development review ordinance, and we're hoping that'll be, early next year. It hasn't been updated for quite some time, a few tweaks here and there. There are a number of problems with it, including a couple of legal problems. There's also, the state model ordinance has been revised, and we haven't taken a look at it yet. Our ordinance is clearly considerably different than that. We still take into account volume, for example. So, do we go to the voters twice, or do we go to the voters once? That's what it really comes down to. Do we go to the voters with just a change to the map? Or do we go to the voters once with a whole ordinance revision? And, that's a, pragmatic question we need to, decide. But, the revisions, I don't know how long the revisions to the ordinance are gonna take, because we haven't even started to look at it yet. And we're unlikely to have the resources of Kennebec Valley Council of Governments at our disposal this time, because we've pretty much exhausted what we can expect from them.
When is the next town meeting?
March.
It's on one, right?
Yeah.
Unless there's a special meeting.
Well, yeah, right. There's usually, these, in Belgrade, the tradition has become for ordinances to be dealt with not at actually the town meeting proper, but in a referendum vote the evening before or the day before. And so on occasion, there have been other ordinances adopted or modified at, say, the school budget approval in June, or, other. We originally, the ordinance we're working on right now, we're finishing up on, we had originally wanted to have that next Tuesday
Right.
because of the large voter turnout.
There's an analogous situation here, I think. I live in Scarborough, and was so many years on the board there, and before that in South Portland. And in both cases, the South Portland and Scarborough have wetlands maps. They're not complete, they're not totally to the inch. And so when an applicant would come before the planning board with a project, the applicant would be required to submit updated site information to confirm where in fact the wetlands were. And oftentimes, we would find that there were more wetlands, and oftentimes we'd find that in fact the map was over-inclusive. And I wonder whether what might make more sense here is if, rather than changing the map for this one piece of property, that we talked about an amendment that would essentially say, at the time an applicant comes forward, the applicant shall present information to confirm, or to, not confirm, but to show, in fact, where the slopes are. And then if we had an application before you, we would say, well, we've done the topography, and in fact, you've got a half an acre here that's shown to be in the slope district, and it's not. It's not a mistake, it's just inaccuracy. That would probably work for us as well. The other thought would be, if, rather than take all your time tonight, because I know you gotta get on this other thing, I'd be happy to talk to Dick Llewellyn, and just to get his take on this, and explain my thought on it. And if he says, I don't agree, and I think this is an amendment process, that's fine. I mean, we're not looking to go to court on any of this. I
Right,
just,
yeah,
we're
no,
more interested in process. I mean, presumably
Right.
this is not a controversial situation ultimately. We just wanna go
Right.
through the process.
Right.
and I think getting to your first point, I mean, I think that was the intent of that language that Peter referenced.
I think so.
Yeah, it seems
Um,
like it.
I think
And,
so. I think that's what they were talking about.
recognizing that, well, all maps, but shoreline zoning maps, particularly those produced probably in the 1970s, have margins of error around the boundaries, and as do wetland maps, as floodplain maps, et cetera, as geological maps do,
Right.
sand gravel aquifer maps, et cetera. It's just that, you know, if you were here wanting to build a camp
Yep, yep, be different.
That's exactly right.
versus, you know, wanting to divide a piece of property up amongst the heirs or among landowners
Right.
and needing to get an appraisal to do that.
Because, like George pointed out at the start, you know, if we had had an application in front of us where a building was being
Understood.
proposed, my thought is at this time, if it were that was presented, we could take action based on what we're finding for language in this section.
Mhm.
But that's not what we have in front of us. It's more of a,
But I think if you craft an amendment, it did include us. Like I said, I see no reason to be going to the voters of the town of Belgrade to say, Wasabi and Furman can move their slope district,
right,
approved or denied. If you crafted language that said that a slope district, the exact location of a slope district shall be determined by survey submitted to the planning board, okay?
Yeah, in connection with an application or
With,
something.
yeah, well, an app. I suppose Wasabi and Herman could apply. So the application process includes this kind of case, not just a site proposal, a development proposal.
Right.
That way, you've actually really solved something. This won't happen again.
right, right.
That's essentially what I was saying.
Yeah,
Yeah.
right.
And
right.
if that were the case, that would be an amendment to the ordinance by
You know,
language,
it clearly would.
which would then be something that would have to, you know,
But that would address this potential problem on other properties.
Right,
yes, it would.
Right.
Rather than, as you put it, a spot change or whoever it should.
right.
I did,
right.
yeah, as it
Mhm.
came from Dick Bourne, from, you know, because that was thought of back in the 90s,
Yeah,
when some of the amendments were made then.
They just didn't realize the possibility that someone would, in a non-development situation, could have a problem. That's all that happened with that section.
Right.
so if we were to pursue something along those lines, what would be the process from here going forward? Would we submit, would I suggest some
proposed.
language and?
Proposed changes to this shoreline zone amendment?
If we propose an amendment to the ordinance that would do as Parrish has suggested, which would be that a landowner shall provide sufficient survey or topographical information to confirm the location of the slope district. I would, probably in connection with an application or something, but,
Can I see my copy of the ordinance?
yes.
again?
And that way you would
Thank
have,
you.
you would have that in the ordinance, and then anybody who comes forward and says, I wanna build on this piece of property, and according to the map, half of it's in the slope district, my surveyor's gone out there and checked the topography, and turns out the map is wrong, essentially. And it's kind of, Paris, the analogy he pointed out was the flood zone, letter amendments. Letter of map
Map
change,
amendment.
what do they call it?
Yeah.
Letter of map amendment.
You can go in and say, look, my property's shown as being in a flood zone, but in fact it isn't, and you fill out a form and you get the topographical information and the elevations, and you submit it, and they agree, and they put this letter in the file for that property. So the map never changes, but the letter of map change overrides it. That's the concept, I guess, we should be thinking about then, rather than asking you to just amend the map as to this property.
Yeah.
So I'd be happy to work with Dick Llewellyn or whatever, or come up with some language and get it to you and work with whoever on the town, and rather than put you trying to, I mean, I have a fairly good sense of what we could do. I have not read the whole ordinance on this issue. I didn't have focus on that section, so,
Right.
But it sounds like that might be able to be expanded somewhat to address.
Yeah, that's.
yes. Any map, final map issues could be addressed in a provision that says the applicant shall provide sufficient survey information to confirm the location of,
Mm-hmm.
because some of the zone lines, zone lines are zone lines, and that's a survey issue. These are based on topography, so if the topography was wrong, the plan is wrong. And an applicant should, I would think, have an opportunity to say, look, your map is wrong, and here's the evidence to show it.
Well, there's land, well, we found 20% land that's not shown as in the district.
Right.
In the slope district, okay? It went both ways.
Well, don't tell them that, no.
They know it.
They already figured that out when they went there.
Yeah, no, I took them by the mountain. okay?
Sure, I mean, it's probably as accurate as it could be, given what work was done.
Yeah, they don't know.
Yes,
On
Roger.
page 78, number 4, so basically, that's what they're getting at, is granting a special exemption, so they'd have to write up something that we could put in there.
What page did you say, Brett?
On 78, number 4,
So granting of a special exception, conditional use permit shall not alter the boundary of the district in which the lot.
I don't think this would be a special exception case.
or a conditional use.
Neither, I mean, they're somewhat synonymous, but that's more a case where there are criteria in your ordinance that say, notwithstanding these limitations on use in this zone, if you meet these 5 criteria, we will grant you a special exception. Or a conditional use usually says, notwithstanding what it says for the zone, these conditions are permitted, so provided you meet these 5 criteria. I don't think that's this case. I think this is a case of having a map that depicts a portion of a property that's incorrect because the slopes are not greater than 20%. And if we were to draft an amendment to the ordinance that would allow a landowner to present that information to the board, and the board was permitted to change that area in connection with a project or whatever, that would get us to the same place. I mean, then we could at least tell our client, we're not changing anything now, but at least there's a process you can go through in the future when you want to build. I think that probably would work.
There's something in there that'll work.
Yeah.
I can't say it yet.
Peter, in terms, getting back to the question about process and timeframe,
I was thinking about that.
I don't, I'm not a master of that, but based on what we've been told by others here in the town office, an ordinance amendment, particularly a zoning ordinance amendment, which this is our only zoning ordinance amendment, requires 2 public hearings, one that this board hosts and one that the select board hosts. And that all has to be completed 45 days before town meeting,
Right.
is what I recall Michael Barrett, the first selectman, telling us. And that's assuming you have the language and all that. So whether or not that could be pulled together before, in time for next March, I have no clue. If we agree to, basically amending the ordinance twice.
Right,
I don't know how the others would feel, but.
right.
So you are in the process of
Well, we haven't started, no. We have sort of this work plan, if you will, to implement the town's comprehensive plan.
I see.
Item number 1 was this commercial development review ordinance, because as you drove up Route 27, you can see why.
Yeah.
And, commercial sprawls marching this way. Number two, though, was the shoreline zoning
That's right.
ordinance, and our general timeline was, that we've talked about was, early next year.
Well, so it sounds like there's agreement this probably isn't a section 10 ZBA process. Is that where you are? And your attorney is there.
It is not, is section 10?
That this is not a change that the ZBA could make under section 10 of the ordinance, where we started this. In other words, I guess I'm saying that unless Dick Flewelling and I chat and he thinks otherwise, I think he's probably gonna continue to take the position that this is more in the nature of an amendment to the ordinance. I think what we're now talking about in any event is not amending the map per se, but coming up with an addition to the ordinance that allows an applicant to submit survey and topographical work at such time as it's been needed to show that a portion of the property that's depicted as being in the slope district in fact isn't, because the map isn't accurate or is imprecise. And that you could build into whatever else you're doing to the shorelands ordinance, and maybe we don't go to the town meeting, or maybe you do, maybe you don't by March, but maybe you go with whatever other changes you're doing, and I can assist in drafting language to address this one issue.
Answer your first question, I can't speak for the others, but that's where I'm at in terms of, I would feel really uncomfortable with deciding that section 10 is what applies here, given the legal advice we've gotten from our own attorney.
That's fair enough.
I feel similarly.
Okay.
Roger?
Then again, though, we haven't, we as a board have not been in communication with
Yep.
Dick.
We know.
It was Jay Bradshaw.
Yeah.
Our 45 minutes is up.
So would it be appropriate maybe for you tonight to vote to table this, or pending further input from council to the
Yeah.
applicant or something like that, and then we'll put our thinking caps on, and I will talk to Dick Flewelling, but I'm not necessarily to try to convince him that I'm right and he's wrong, but more in terms of process.
Well, as you probably have already guessed, I'm married to Becky Seal,
Oh,
and who also works at MMA and is a colleague of Dick's, and I suspect you're gonna hear that there's some case law relevant to this.
so Harvey was your father.
Yep.
Oh, I'm the president of Scarborough Land
Right,
Trust.
and I knew you were on the board, or at
Years ago.
Yeah. But, yeah, Maine's a small
It's a
place.
small state.
Yeah, yeah.
Well, the Warren family was kind enough to donate a beautiful piece of property to the Scarborough Land Trust. Yeah, it was a donation or we bought it, but whatever it was
You
a fair
purchased
deal.
it, but at a good
It
deal.
was a very fair deal.
Yeah.
I know your wife well.
So, there may be information out there that, we're not privy to
Right.
on us, so. I would, I think that's a suitable way to go, and
I agree.
I would make a motion that we table the matter until there's more information.
Your next
forthcoming.
meeting is?
Pending further submission.
Yes.
From council. And so
Yeah.
Your
That's
next
fine.
meeting is the
That's-
17th?
Our next one is, yes. Yeah. 14 days from today.
Yeah, I mean,
All right, so you made the motion, I'll
Yeah.
second.
And you need notice next Thursday if we want to be on that agenda, right?
Yes.
Or should we
Yeah.
just ask to be on that agenda?
Let Gary
2
know.
weeks.
Kick it around, let Gary know.
Yeah, we may not get that.
Gary puts together our
I'm
agenda.
just thinking of
I understand. I'm
other
just
things, and I
cross,
wanna chat with John about this.
So any more discussion? All those in favor? Tabled.
thank you, John.
Thank you so much for your time, I really
Yeah.
appreciate
Oh,
it.
thank you, this is a good discussion.
And
Thank
really,
you
thank you for
making
hearing
the long
out,
drive up.
hearing out this, in particular, this other language, which I know Parrish heard me talk to the select board about. This might offer some avenue for us.
Good. Good, say hi to Becky.
I will.
Thanks, guys, have a safe journey back
Yeah.
home.
Last
Yeah.
time I drove up there was raining, too. It's tough drop.
Probably the next time it'll be snowing.
Yeah.
I know,
Watch your
that is likely. That is likely. So I would like to hang on to this. This
No.
goes in here.
And
Nick, I'd like to have you hang on to this piece. I really know where.
Rally point.
Okay.
Good night.
Bye, guys.
Thanks very much.
Have fun.
Okay,
Always.
Sounds quick.
say hi to Jesse.
If it isn't fun, we wouldn't be doing this.
Yeah, that's, I was chairman.
I thought you were doing it for the big
I was
money.
chairman of the
Roger.
field
Well, that
committee.
too.
Yeah.
Don't tell anybody.
You know what it's all about.
Which one of these are we working on?
Yeah, that's a good question.
Yes, it is.
So for us, the, Nick, you're the one that does not have a date, right?
That's correct.
I got it out.
So not this one, it's not this one.
There is an analogy.
Yes.
We have one for,
I printed the one, well, I've been using the one that Nick provided us, which I
That's
assume
the
is the
good
same
one.
one that's on the
Get rid of
website.
these.
yeah.
Put them right in. Yeah, wait a minute, here it is.
I know Rich had an old version that he was working off of, that's why the town, the
Yeah,
page name.
That's the same, right?
Yes, yes it is. So,
Let's get rid of these.
okay, let's see.
And we'll keep down, put Rich's name right on that one. Cause he had an old one too.
Yeah, he did.
Okay, no.
This is for Rich. Okay, so we'll give this to Rich. So, we're on to the primary reason, or the old business, I suppose, otherwise called, which is taking, we have the letter from Mac somewhere. This one. So, and you have given copies to the other guy?
Yep.
Awesome.
So we have really, Mac, Stucco's, is that how you pronounce his last name? Email, we have the comments he gave us verbally at the public informational meeting, which are, broader. It covers areas not covered in his email. And then we have, the email from, Dick Bourne and his comments.
Right. So, if we tease this out and kind of look at both,
Oh, and we have a suggestion from Michael Barrett too.
what was his? Is it-
His
was
had to also do with, signs, which was a subject of, that Mac.
Was it in an email, or was it just verbal?
No, he said he made a suggestion verbally,
Okay,
at least that I wrote down anyway.
okay, thank you. All right, so shall we tackle this section by section as we see them from the
Sure.
comments?
Yep, sure.
Okay, so let's try and keep some semblance of order here. So from Dick, if you don't mind, looks like Max are at section 9, so if we can hang on to that thought, maybe start with some of the earlier ones from,
Yep.
from Dick. Dick looks at sections 3 and 4 and notes 4 potential problem areas.
Yeah, there are a number of places where we use square feet, and he raised the concern that, although that implies footprint, we should say so. And so I went through and looked at every place that I could find where we made reference to square footage, and found a number, but on that, I guess, page 3, which is in Article 3, the Section 1, the applicability section, basically, there's in A, that definitely should be changed to by adding the language in footprint area.
So where it says.
Nick, what's the easiest way for you to keep, kind of keep up with these? Because we're obviously gonna rely on you to type these changes up.
Just go ahead and I'll keep up with you guys reading along.
All right, just stop us if we get on a roll.
Okay.
So what, George, I think where we are, you said is Article 3, Section 1, A, end of that sentence where it says in excess of 12,000 square feet.
Mm-hmm. Add in footprint area.
So just to recap that, just by example, right? So then it will now read in excess of 12,000 square feet in footprint area. So it's not just a unit, it's a unit, and I'm gonna call it a description. Are we good?
Likewise, in F also of Section 1, third line down, which starts off square feet of, I would suggest inserting footprint. So it reads square feet of footprint area.
Yes. And next was G.
Great, same thing, 1, 2, 3, 4 lines down of 20,000 square feet in footprint area. When I went through this, 1A, I think, is where there's the opportunity for any confusion. The other places, it's really pretty clearly implied that it's, in footprint area. It couldn't really be much else, but it seems to me if we make the change one place, maybe we should do it everywhere on it.
Totally agree. I mean, I think having clarity up front, especially for applicability, I mean, that's the foundation.
I mean, I think Dick is coming from the shoreline zoning ordinance where this is probably even more important than here, but, but his point's well taken.
It is, it is.
Now, the other thing I had on that page was, and you may recall this discussion from Mac, was in 1F. He took issue with the changes that we made from the current ordinance where we, in the last 3 lines, exempt paving or repavement of existing paved or impervious surfaces,
Yeah.
i.e. parking lots. And his argument was we should use this as an opportunity to capture those, to deal with stormwater coming from those. I appreciate the sentiment, but I don't think this is the right ordinance to do that. I think my recollection is that Chris Hawk had recommended this change on the basis of trying to, as much as possible, with the exception of things like the existing gravel pits, keeping this on new development rather than properties that are already developed.
Right.
I mean, the fact of the matter is, I forgot that the way the ordinance is currently written, and so probably when Hammond Lumber early in the summer repaved their parking lot, probably triggered this ordinance.
Oh.
Because I bet you they did more than 10,000 square feet. And so the question becomes, is that really what we're trying to capture?
Right.
I
That
mean,
is-
it's no harm, no foul there in the, at least in terms of the environmental impact, because DEP forced them to build that stormwater collection system there for the entire facility.
Correct.
So, you know, I think that's the potential impact. Although it's always been paved, I mean, it's probably generating the same amount of stormwater today as it did before, but.
I can see-
I guess I'm of the opinion not to make that change.
I can see them actually thinking about, it, especially in the village, because if they repave, everything is going into the water now. And that's the time to catch it, but it's not an environmental ordinance. It's a commercial review ordinance, so I don't know if we can actually make people spend that extra money just for repaving. Well, he's got a good point. That's a good time to catch it, to get them up to code of today's standards. Because like he said, back when they did it back then, 20 years ago, we weren't thinking about environmental stuff. Today we are.
I mean, the way it's written in the current ordinances for repaving, when you're exceeding 10,000 square feet, there aren't too many parking lots in town
No.
that are 10,000 square feet or larger.
No, somebody would have to buy 3, 4 houses, tear them down and
Yeah,
turn the whole
yeah.
thing into a parking lot.
Yeah, exactly.
So, you
And
know,
that I think if they do that, that would trigger something that they'd have to come up with.
anyway, yeah, so, you know, I can't think of anything other than the parking lot at Hammond Lumber, to be honest with you.
You know,
It's of that size, but,
yeah.
you know,
10,000
not
square-
even the school, I don't, maybe the school, I don't know.
Because 10,000 square feet would be 1/4 of an acre,
Yeah, maybe the school.
maybe, you know, and
So, anyway,
so,
my thought is, I think we should go with the changes that Chris,
Yeah.
I'm of the opinion we should stay with the changes that Chris made, and I understand what Mac was saying, but let's stick to the plan.
yeah, I think this would be, that change might be problematic with the voters too.
Yeah. Yep. Um. So relative to, I think, Dick's concerns, are we okay with what he said for Article 3? Because he has 1, 2, 3, 4 things for the first part, and then the next part goes to Article 4.
Correct, yeah.
But I don't-
Everything up until that is basically all the same
Right?
issue.
Yeah, exactly. So then for Article 4, Section 4.1. 4.1. Expiration, I think is what is intended. What? 4.
Yeah, he was saying 12 months is way too long for them to be able to start it.
There are a couple other places where we use square footage in Article 4 as well, that we may wish to. But let's finish up with what you're, because that's more kind of substantive.
Oh, yeah.
Yeah,
Oh, that's right, yeah, I did go ahead a little bit.
no, that's okay. Why don't we finish up on your thought?
So, thank you. So Article 4, Section 4.1, expiration. Dick's talking about the phrase, "from the date of the town's approval for the substantial part of the construction," seems to confuse the issue, since the town issues a permit, not an approval for the substantial start of construction. I think Gary talked about that.
He did, and Gary added the point that, you know, the way the ordinance is crafted down, the way this language has been amended, neither says how long, has anything to do with how long it takes to complete the project. It has to do with how much time do they have to make a substantial start. And, I mean, I think Dick and Gary both have a good point, and so I think the language needs to be tightened up a little bit. And I have a possible suggestion for you guys to consider.
Sure.
Why don't I just read it? Don't worry about taking it down yet, Nick, because others may have better ideas than me. But, so, how best to do this? So we have expiration, okay, permits are valid for 12 months from the date of the town's approval for substantial start of construction. Well, as Dick said, we're actually granting a permit. We're not for the whole project, not just for substantial start. So I was suggesting changing that first sentence to permits are valid for 12 months from the date of town's approval, comma, and construction must be substantially started within this time frame. And then eliminating the rest of that existing sentence.
I'm not trying to get too wordsmithy, but those sound like two separate sentences.
Well, it could be. We could do it two sentences, yeah. So it would read, permits are valid for 12 months from the date of town's approval, period. Construction must be substantially started within, maybe say, this, well, either this time frame or within this 12-month period, something like that, time period. And then I think Dick was of the opinion that 3 years, and I think Matt was too, Mac rather, excuse me, that 3 years was too long and excessive. So one idea would be to just reduce that to, you know, 1 12-month extension rather than 2. If that.
Does Gary still give him an occupancy permit?
What's that now?
Does Gary have to give him an occupancy permit?
I don't know. I don't.
You know, when he goes in and he checks the plumbing's okay, and the
Yeah,
electrical's
right,
okay.
You're right, there is I don't know about other aspects of, say, a home construction or versus a business construction, but I know there's, if it isn't an occupancy permit, it's sort of the equivalent of that when you build a leach field.
Yep.
You know, one, they approve its construction and then they approve its use, and it requires a second inspection. But in terms of, you know, somebody building a new non-resident, you know, a nursing home or something like that, I don't know at the local, maybe there is at the state fire marshal office, but.
That's a good question. I'm okay reducing the extensions from 2 12-month periods to 1 12-month period. That would diminish, you know, languishing kind of efforts that just go on and on. If it's gonna die, let it die, and if, it is not to say that if a person comes into financial hardship or whatever reason they have to extend and it goes beyond the once extended, they can come back and get a permit.
Right.
Or seek approval for a permit.
Right, they just have to start
Just
fresh.
have to start anew.
Yeah.
So I'm okay with doing that. So, Roger, how do you feel about that? I mean, I don't wanna,
Oh, I'm all for that.
yeah,
Like I said, they've got 2 places going now where construction stopped, and they could sit there for 2 years before they start again.
yeah.
Well,
So, yeah, you know, I wouldn't want, personally, I wouldn't want something to be started and then just hang around for 2 years doing nothing.
yeah.
Right.
You know, because where's that gonna take place? It's gonna take place along the corridor, Cause that's where we've said we wanted to have stuff happen. So, in my
The-
opinion, I don't
the-
want the
the-
eyesore.
The other thing that came into my mind, and I'm kinda worried about it, is if a company like that would come in and ask for waivers, like Dollar General's doing, they start construction, they delay it. 2 years down the road, they're hoping that a lot of this is forgotten, and they sold to somebody else, and they take over those exceptions without even having to come to us,
Oh,
you know? Like Dollar General, if they're gonna want these waivers and stuff, and in 3 years they go out of business, whoever takes over that building gets everything that we gave it to them as an exemption. You know,
yeah, they get it all,
Yeah.
whatever.
that's what bugs me.
Yeah. So let's kind of
Anyway.
recap those.
You want me to
those
Yeah.
reiterate? So
Sure.
the first two sentences, changing that, are you guys good with that?
I'm good with it.
And I like the part when they go in the back for substantial start, what that covers. It's 1/3, 30% of the construction and 1/3 the cost.
Is that by definition?
Is that in the ordinance now?
Yeah,
It is?
that was in the
Okay.
back. I saw that under the.
I didn't even think to check.
Yeah, thank you, Roger, that's good.
Yeah, that's good, that's an important point. Okay, so, Nick, for your benefit, end the first sentence after the town's approval, period. And insert a new sentence that reads, construction must be substantially started. Well, wait a minute, you know, if there's a definition in the back, maybe that needs to be reworded. Just-
Was that under substantial, Roger? Or,
Substantial starts, you have definitions for that.
yep, page 49.
49? Oh, okay. I went under substantial and it isn't there.
Yeah, mine's upside down, isn't it?
What page did you say, Peter?
49, next, third from the bottom.
Okay. The page numbering's different in mine, so, anyway, let me go back to the definitions. And it's under start?
Substantial start.
Oh, substantial start. Oh, there it is. Substantial start, okay. So, let me think about this. So, how about this? Let me just read it first. A substantial start of construction must be completed within this 12-month time period.
That's good. That will work.
Yep.
Okay, let me reread that for you, Nick. A substantial start of construction must be, what was the term I used?
Completed.
Completed, within this 12-month time period.
I really like that because that's consistent with the definition.
Yeah,
They use
the
it
way I
same
had it before, it wasn't.
All right, you wanna go down and change 2 to 1 also for extended maximum?
Yeah.
Yes. See, change 2 to 1, 12-month, and rather than periods, it will be period.
Get that, Nick?
Were we?
So in the same section 441, the next line down, where it starts off, it says, may be extended for a maximum of 1 12-month period.
Yep.
No S and then period.
Hmm.
Not to be confused. Okay, and then we should, I think, as George pointed out, go back up just a little bit on the same page. George, is that okay?
Correct, that,
That was the one where where Dick pointed out, this is, Article 4, Section 3(1), subsection 1,
So 7,500 square feet add in footprint area.
so that's at the top of the page, right where your thumb is. So it says, does not exceed 7,500 square feet in footprint area would be inserted, those three in footprint area. Okay? So that would take care of all that, and then we'll get down to,
There's one more square footage one ahead of that. So it would be section 3, 3.1, code enforcement permits, paragraph 1, second to last line, 2,500 square feet in footprint area. Add in footprint area.
thank you. So do we catch them all?
I think that's it so far. I think there's one further along. We can
Okay.
catch up to that.
So then going forward in the ordinance, are we now at Dick's, let's see, Dick's item 3, definition of building footprint?
Okay, before we get to that, on the same page is the expiration language. The next 4.2, transferability. I found a sort of a typo.
Okay, hang on.
So
So we're in applicability, right?
we're under, no, not Article 4, yeah, Article 4, Section 4, Permit Administration, 4.2, label transferability,
A permit is,
transferable to subsequent owners of the property provided.
oh,
Yeah, so I think that needs to read, I think it's meant to read, provided the permit has not expired.
Right.
right, oh yeah, cause I started this, cause the wise guy in me, wanted to say, not that the permit, not that the applicant has expired. I didn't say it, but I was inside, I was screaming to say it.
Right. So you see where we're at, Nick?
Mhm.
Did you get that okay?
Okay, thank you. It's funny, English language.
No expired applicants may apply.
Only live
Need to
applicants.
apply, need to apply.
Okay, thank you. So are we on, see, Dick's
Did-
item 3, definition of
we skip-
building?
Section, see, over here, he says, third section, 1B, compounds the confusion by stating an existing residential building. Did we skip that?
Oh, we may have, I guess I was thinking that it was
Yeah.
just another matter of clarification. It goes on to say that exceed 25% of existing footprint of structure or structure. I'm suggesting at least
That's
some
under
careful
section
wordsmithing.
3.
Yeah.
Where are we now?
Oh, so where we are is, we're back in.
He had 3 things in section 3. This
Okay.
is the third one,
Article 3,
section 1B.
Oh, okay.
section 1.
I missed that.
So I'm suggesting that at least some careful wordsmithing, or perhaps even better, a simple decision table of the criteria is desired. A number of difficult scenarios come to mind unless the intention of the section is crystal clear. Expansion.
guess I don't understand his point.
I don't think I do either.
Because that language seems clear to me, but I may be reading it with a jaundiced eye.
So what we're saying right now is that this applies when the expansion of an existing non-residential building or structure. I wonder if that should be a comma and not a semicolon. Including accessory
All
buildings
right,
and
the
structures.
way I'm reading it, I'm looking at it now is if the expansion you're gonna put on is to exceed 1,200 square feet.
The expansion of.
Further, it goes on to say, or if greater than 1,200 square foot in footprint area. This probably is intended to qualify the footprint area's proposed expansion, but could be interpreted to mean if the expansion would cause the footprint to exceed, footprint area to exceed 1,200 square feet.
I think I'm with you, Roger. I'm reading it that expansions that are, I'll say, are either 25, that exceed 25% of what it already is, or if it's greater than 1,200 square feet, that's where this would apply.
We know what we wanted when we put it down, but he's the one that's apparently not getting it.
So we have to be clear then.
Right.
So the expansion of an existing non-residential building or structure, I strongly think that we should have a comma and not a semicolon, because a semicolon is basically separating two
Yeah,
complete sentences.
right, yeah, no, that's,
And we're trying to qualify this.
yeah.
So, Nick, do you see that part?
After structure?
Yep. Including accessory buildings or structure that exceed 25% of the existing footprint, or if greater than 1,200 square feet in footprint area. I think what would, correct me if I'm wrong, if you have a 1,000 square foot in footprint area building, and you increase that by 25%, this would trigger it, is that correct?
Mhm.
Right.
If you had, let's see, what happens if you had an 800 square foot structure that increased 25%? And is under 1,200 square feet. Are we saying that could also trigger it?
Yes,
I think so too.
and I guess that's his point,
Yeah, because that would depend on the size of the building that you are doing work on, because 25% could be less than 1,200 square feet.
Right, so if I say 800, and I'm just tossing numbers, I said 800 times 1.25.
Maybe we ought to just drop off that 1,200 square feet, period.
No, I don't think we need to, but I think we, and I don't think we want to either, but, I almost wonder if we need to break this up into two sentences.
Yeah,
Yeah, maybe so.
I mean, it might sound kind of redundant, but,
I'll have the first line explaining it, and then have two sections where it says 25% will kick it, and 1,200 square feet will kick it in. you know, like what's including accessories, building and structures, period. A, that exceed 25%. B, exceeds the footprint greater than 1,200 square feet.
I think you're on the right track, Roger.
I think you're on the track.
So
yeah.
that breaks out the two of them.
So
Yeah.
maybe, so one way to do that is basically itemize it the way Roger's suggesting, and inserting language, something along the lines of, let's see, expansion of existing. So on the second line where it goes, proceeds to that exceed 25%, insert after exceed either one of the two following criteria, colon,
Right.
A, 25% of the existing footprint, and B, if greater than 1,200 square feet footprint area. But
So
it would
that
be
way,
like,
yeah, so that way if they're looking at it and they're not gonna go 25% more, but they are gonna go 1,500 square feet, then it's gonna kick in.
Right. So,
so that would then read something along the lines of, something like this: the expansion of an existing non-residential building or structure, including accessory buildings and structures that exceed either one of the following two criteria. A 25% of the existing footprint, or maybe that, let's see. Yeah. Semicolon, or, and then B, if greater than 12.
I wouldn't put or, I'd put B, if greater than 1,200 square feet.
Okay.
Because just that word or, they're gonna say, well, we're not going 2,500, but we're doing a little over, you know. You're still giving them a choice of one or the other. By doing it just A and B without the or there, either one is gonna kick it in.
because I think
You're
that's
really
what we want,
breaking it
right?
up. You're really breaking it up.
Because, let's see, an 1,100 square footprint area building that applied for an expansion of 15%
Mhm.
would kick it up over 1,200 square feet.
Okay?
So I'm thinking that would be an example of where,
Yeah.
since it's over 1,200 square
Mhm.
feet, this would apply. Yet
But
at
because you're
800
breaking it up in A and B, I don't think I'd put or in there.
Yeah, I know what you're saying, yeah.
So does that work with that, with eliminating or?
To me,
I
that,
think so.
Yeah.
Nick, can you read it as we have it, as you have it?
it's like he's got it down here, it's a better decision table.
Yeah, that becomes a whole,
Another
a
thing.
new challenge in its own right, I think.
I think we can be crystal clear with this.
Yeah.
I'm pretty confident.
Yeah.
Because we're pretty much there. Nick, sorry,
Do you want to read the entire B or just the part that you guys had to,
just the part we're changing.
that exceed either one of the following of the two criteria? A, 25% of the existing footprint, or B, if greater than 1,200 square feet footprint area.
Eliminate or. Just have, semicolon. And rather than, be consistent with the formatting, rather than using a small letter, use, Roman numerals 1 and 2. Not Roman, Aramaic. Arabic. Aromatic. Yeah. The spelling numbers.
I have a question, see if you guys agree. B ends with footprint area, A ends with footprint. should we be consistent?
Yeah,
Do you like footprint area?
yeah,
Can we do that both? Thanks.
yep, that's important.
Yeah, it's small, but it's one of those little
Mhm.
Good
things.
thing you brought that up, Roger, I missed that entirely.
Okay, so I think now we've tackled.
Good for
from-
one thing once in a while.
We've tackled Dick's comments for first, on his letter, first it says, and then second, and then third, and fourth. I think we've tackled all those, I believe. And then we've also tackled 2. I think the next for us was look at 3, definition of building footprint. So a definition of footprint.
There's no definition now, nor is there in the current ordinance. There is floor area, but that's because of, that's needed elsewhere in the ordinance. I don't know that I agree with Dick on the need for a definition of footprint. That just seems to be such a well-understood concept. If this was shoreline zoning, and the example he gives about where you have overhangs and stuff,
Yeah, setbacks and.
but, you know, that's pretty unlikely with,
I noticed in this morning's paper, Augusta just changed theirs. They don't use area anymore. They went to the people for that. It's all footprint now. So the roof size doesn't count anymore.
that's in their shoreline zoning, right?
Yeah.
Really?
Right, yeah, that's part of the changes
So
that
that
the
took
state
care of
made.
one of their problems.
Okay.
Actually, I just had a thought, I wonder if there's a definition of footprint in the shoreline zoning ordinance.
I don't know. Let me
'Cause it's-
look.
Yeah, I got it
Oh.
right here.
And I'm not being a wise guy, I was just thinking about, it's a ubiquitous term, footprint. It's like, do you define acres in the,
Well, there's a definition in here,
of footprint?
yeah. But, you know, Dick uses an example that apparently was problematic at some point when he was on the planning board, that this definition was still problematic. But anyway, the area, it's defined as the area of the projection on the ground of the outermost perimeter of all above-ground elements of a structure. So if you have a second floor with a larger square footage than the first floor, it would be that,
So if it was like this and then
yeah,
like this, like a raised ranch except on steroids, right?
yeah. I was thinking of a French and Indian War fort, but.
Right, right. And, or perhaps, because I think Dick talks about a cantilevered porches, but if you had all cantilevered second floor,
That would,
that would, I mean, it would be weird, but it could
Yeah.
happen.
I mean, that's why I say I can see where it's important in the shoreline zoning. I don't know. We can do whatever, but,
In commercial review, there is a footprint definition.
there
The
is.
current
Yeah,
one?
right there. Well, that's in the old one.
Ah.
An area, the area covered by a building measured from the exterior surface of the exterior walls at grade level, exclusive of cantilever portions of buildings.
So that's different than,
Oh, that's different than shoreline zoning, and that must be Dick's point.
Yeah, where the building is elevated above the ground level on posts or similar devices, the building footprint is the area of the building would cover if it was located at ground level.
so the big one
Oh,
applies.
So the
building
guy that built
footprint.
my house tried to cheat with that. The bedroom closets are on cantilever.
Oh, and, oh.
And he
Yeah.
thought he wouldn't have to pay the extra taxes, but he got nabbed on it. But there is I don't know if the new ones should have it in there too.
It did not, at least I did not see it under F for footprint.
It's got floor area.
Actually, hang on, there is something called building footprint.
Building
Yeah,
footprint, that's it.
that's why I didn't find it. I went to footprint.
Yeah, it's the same thing, that didn't change.
So Dick's point is, he's just pointing out the difference with the shoreline zoning definition,
Yeah.
I guess.
So when we get to the other one, maybe we ought to take a hard look at that, how that one's written out too. So that way it's all
Yeah.
footprint, not, yeah, just
One-
area, yeah.
Yeah.
So we're all on the same basis.
Well, are we okay realizing that we do have a definition?
Yeah.
First of all.
Right,
in
which
this
is a
one,
good thing.
Which is a good thing. And then, is there a need to change anything in the current definition of building footprint?
I don't know, the way it's written out here, I kinda like it. I mean, you're not addressing roofs, but then again, I never went for roof overhangs as should be, should be part
Yeah.
of it.
Well, and particularly for this ordinance,
Yep.
there may be a good reason why in shoreline zoning, maybe that's more important, but I don't think so for this ordinance.
The only way it would cover it in shoreline would be the amount of area you're covering to catch the runoff.
Right. But that's,
But in this case, we're not
Yeah.
doing that.
Right, different
I would say we
cases.
stay with the current definition.
Yep, and recognize there's a difference, perhaps for good reason,
Yep, yep, right.
in each ordinance.
And we'll probably revisit that anyway
Yeah,
in the other ordinance and so.
indeed. Okay,
Okay.
I'm good with that. That's really nice of Dick to have taken the time to submit.
Well, also, I'm following this other page that we got from the other one that couldn't make it, from
Mac?
Richard. And he's got almost the same thing that we're covering right now.
Oh, yeah, it's from Dick Bourne.
Yeah.
Yeah,
So he had the same things as Mac, and then we're here, we just covered that one for him, so.
and see, I'm reading these from Dick.
Yeah, you got, I
Yeah.
got Dick's here too, but I'm also looking at this other one, so.
Okay. So then, if we've covered Dick's concerns here, then we have Mac's concerns. Are we on the same? are we
Yeah, and,
progressing?
I think the next one of his that pops up is, on section, 5 of Article 4, 5.2 in fact, code enforcement officer review, he objected to the whole concept of code enforcement officer issuing any permits.
Now, is that from notes you had, Kevin?
Yes.
Okay,
Yeah, I took notes that, abbreviated all as they are, but, and so he took issue with the whole concept of very small projects being only requiring a permit from the code enforcement officer. But in particular, the time of the code enforcement officer should be put towards that task, which, is a good thing to think about. But we've had before we went this route, we had conversations with Gary, and he's on multiple occasions said he saw no problem, particularly given how narrow the scope is.
Peter, do you want Mac's thing? It has all his notes in it and stuff.
oh, yeah, thanks. Thanks, that could be helpful. Keep that here so we can.
And I guess I should say that this concept comes from of having smaller permits only, the smaller projects only have to get a permit from the code enforcement officer, not have to go before us,
Right.
is a recommendation in the comprehensive plan.
Right.
So I personally don't think there's any change needed. If Gary said, geez, I just can't do this, then that would be a different thing, but that's not what he said.
Right. I had it, George, what would you like to do? Would you like to proceed here with some of the things that Mac brought up before in like sections 5? Or did you wanna go to like the comments that he had in the email regarding section 9 and go through some of those?
I mean, we don't, you know, you know, we got limited time here. The most substantive changes that, or things that Mac discussed had to do with section 9, and then also with lighting, and then with signs. So we could jump ahead to those sections, or those portions of the ordinance, and then see if we have time to deal with some of his other comments.
It might be good to be able to do some of that. Yeah, go to 9.
Okay, let's
Okay.
do that.
Article 9?
No, I'm sorry, I said section 9, didn't I? And I only did that because I read it that way from his,
So that's parking
yep.
in
So that's,
Article 7, right?
so yeah, so Article 7, section 9.
What page you on?
So on the new one, it's page 26. I had made a note to include a segment to reduce parking like Augusta did.
Yeah, he was arguing for a standard for maximum parking standards, but his email takes a different tack. Or at least address the same thing, but, and he jumps ahead to that table, or the preface to the table that specifies the number of parking spaces, which is, I guess it's paragraph 4, so it's like 3 pages further. And so he's, actually, I'm sorry, I'm screwing up here. Section 9 parking, I'm actually in the second paragraph. So why don't we just finish up with that?
Okay.
He suggests adding language that the table below lists the maximum number of parking spaces allowed subject to adjustments. And the subject to adjustments is in 5, where it gives the board flexibility to adjust it for 10% either way, up or down, based on what, you know, like for example, Dollar General said they had information on, you know, parking space usage, and assuming they presented that at some point in the future, we might be able to adjust the number of spaces needed. I don't really like his suggestion, but I didn't know quite too much about the source of these. So I went back and I looked at this document that's referenced here. It's called parking, actually it isn't called parking demand, it's called parking generation. And ITE is the Institute of Transportation Engineers. And what those are, what's listed here are actually the number of parking spaces based on updated studies on parking lot use. And so it's more like an approximation of the ideal number, not the maximum, not the minimum. And so I don't think calling these maximum, I think that's pretty arbitrary, you know, and it's not consistent with the source. So what I was going to suggest was, first off, I do agree with his suggestion that we should get rid of the language that says shall be interpreted as a guide. That just causes a lot of confusion. I think we should replace that with, something like provides the basic standard for numbers of required parking spaces for various proposed land uses.
So just, hang on just one second, I wanna make sure that we're all caught up. Do you know where we are?
No.
Okay, so what we're doing, George is able to take from Mac's, email. So it's Article 7, Section 9, parking, 4A, so he's down here,
Okay.
right? So 4A, can you see where, and George just referenced the table below should be interpreted as a guide, and then he had a suggestion?
Yeah,
So
So-
that's where we are,
Okay.
correct.
right?
Gotcha.
And so my suggestion is that we eliminate the language "shall be interpreted as a guide" and substitute the following language instead. And I'll just read it quickly, and then I can, if we decide to do it, I can reread it. So that it would read, this table below provides the basic standard for numbers of required parking spaces for various proposed land uses, comma, and then this sentence continues on. Does that
Sounds good.
sound
Mm.
reasonable? There's actually a subsection reference further on in that same, it refers you to subsection 2, it's actually subsection 5.
Okay.
So why don't I repeat that for you, Nick?
Yep.
So, again, the second line of that paragraph, cross out "shall be interpreted as a guide," replace with "provides the basic standard for numbers of required parking spaces for various proposed land uses."
Mhm.
Got that?
Yep.
And then on that same line, it goes on to say, subject to adjustments in subsection 2, it should actually, 2 should be 5. That's an error.
Great find.
Oh, yeah, and on the next line, the title of that document is incorrect. Partly because I suspect it's changed over time. It's parking, not parking demand, but parking generation. And the date is not 1987 anymore, it's 1999.
Woo! Almost 2000.
Yeah, I know.
Almost.
Oh, wow.
They almost caught up.
Only 17 years ago.
Okay, so if we do that, I think this. But the language encourages providing less parking. It makes it easier for those wanting to provide less parking. Meaning instead of having them to prove they can provide less, they simply provide less because they're under the maximum. And we're not really caring about maximum.
Well, we're not directly,
It's not-
because these engineering standards are, okay, this is what, based on at least the 1999 studies,
Yeah.
the ideal number of parking spaces for a mini mall of X number of retail stores, for example. Then, but we have the authority to adjust that by 10% up or 10% down
Right.
in paragraph 5. So that's where you get into is this parking. I mean, more than likely, what's gonna happen is what it's already, sort of raised its head with Dollar General. I mean, parking spaces are expensive to build.
Yep.
So people are gonna be asking probably more often than not for to build less rather than more.
Right.
And then we'll be in the situation of making a judgment about that. Because the flip side is we don't want so few that people end up parking along Route 27.
Gotta go up, not out.
So,
Parking garages. I'm all about it. I don't know.
That's expensive.
Well, everything's expensive.
anyway, that was the best I could come up with.
That will work, I believe. can we go back to Max first?
Right.
So we go back a little bit, but still in section 9, so Article 7, section 9. Then we have something called interior, so it's, section 9, 1, 2, 1, 2B. Max says I think we should require islands for parking lots exceeding 10 spaces. Current language is 100. Which basically means it'll never happen in Belgrade.
No.
I don't happen to agree with that because we're gonna see it at some point.
Yeah, I don't agree with it either, and particularly his rationale, which is based on dealing with stormwater, that these islands could be used as infiltration areas. I mean, that's not, islands are intended to maintain a safe traffic flow, because they're usually curved, and that's why they're islands.
Right.
I think the stormwater section does an adequate job of dealing with the stormwater. So to throw something in here just kind of actually takes a step backwards, you might say, or at least I think Chris would say, because it kind of mixes and confuses different standards by, you know, like putting stormwater into parking. Plus 10 spaces, that's not many spaces, and they have,
That could kill an ordinance. I mean, people could say, how are we gonna plow that thing? I can just see that.
right, that's a good point.
And
And I don't even know how you would,
10.
yeah, 10, that's very few.
It is very few. And so if you had 12 parking spaces, you're gonna have to have an island, because that would exceed 10. So just
Right.
think about a 12 parking spot.
Well, right out here,
Would have to
have
have
to have
an
an island
on
in
that
between
side.
one row and the next. Actually, this is a good example. If your concern is stormwater, doesn't it make more sense to deal with it the way it's been dealt with here, with an infiltration basin and, you know, adequate lawn and other areas for, you know, runoff to
Yeah,
infiltrate into the ground rather
Just
than.
put a catch drain every 12 spots and slope it that way, that's all.
In my mind, yeah, I'm thinking so, and I think I understand what Mac's coming from, if he's thinking about really land constrained areas like in the village, the Belgrade Lakes Village.
Yeah.
He might be thinking about that.
Yeah, he may be, he may be.
And what I'm thinking about is,
And in fact references the village.
yeah, he does, and he mentions some reasoning, and he has an opinion that he has, but either way, aside from that, say if you're the golf course, say you're gonna build a hotel at the golf course. Right now, the golf, you know, you would have some land perhaps, and you'd take advantage, like how this area did, for its parking. I would think that would be the approach to do,
Right.
rather than to use islands. I guess I'm not of the opinion, I'm not a traffic engineer, but I'm just not seeing how that makes sense for,
Yeah.
to use islands for the purpose of stormwater techniques, in this case.
No, they could be used for that, but that wasn't the reason for it.
I mean, down in the village, yes, you know, there's a lot of stormwater generated down there now, none of which is gonna come under our purview under this ordinance. And
Correct.
I always get confused under what ordinance the Lake Resource Center got approved under. Was that just shoreline zoning, or was it this ordinance? as well?
Commercial. Yeah.
Commercial. But in that case, you know, the stormwater, I don't know how many spaces are there, probably isn't even 10, actually.
Yeah.
But the stormwater is being dealt with through a series of rain gardens, there's the permeable parking. I always have a question about how well that works over time, but, you know, in terms of that water, there's other ways, and they've, you know, used some of those.
Right, and I would say since I was on the board at the time when that was approved, I was impressed by the ability of the creativeness that the applicant, or the creative part that the applicants came to the board with to try to deal with some things. Now,
Right.
how proven they were, I guess, I for one, maybe had hoped that what they presented, I believed in what they presented. Over time, I may be proven wrong, I don't know.
Well, I only say that, I really don't know about their parking at all. I just know we had got some from DEP about the use of those permeable pavers, and that we should reduce the amount of stormwater, that they only infiltrate about 50% of what they say they would, because of compaction over time by vehicles,
Yeah.
of the gravel that's in between them.
Yeah. So maintenance is required with those, of some
Yeah, I
kind.
guess so. I'm not
Or
really
some
sure.
vacuuming, or, I think, but
Yeah,
I'm probably getting off track, but either way, I agree. you
but
know.
anyway, that's neither here nor there.
Right.
I think, I just don't agree with this comment.
Yeah. Yeah, I guess, I understand the sentiment, I guess I would prefer not to take that particular suggestion and alter anything with regard to the way we currently have the revised ordinance. That'd be my take. Roger, do you wish to stay with what we have, or?
Yep,
Yeah,
definitely.
Okay. So I think Max, I really appreciate Max's very thoughtful approach to this, and for writing up these things, it's really excellent to hear. Thankfully, we have concerned and engaged citizens, this is excellent. Okay, what's that?
Now, when he was at the public informational meetings, he's clearly, you know, an issue that's important to him is sort of the dark sky kind of stuff, and minimizing light pollution, which, you know, is commendable. So he gave us a number of comments about Section 8, which is the exterior lighting,
Yeah.
and then on the signs, which is Section
Is it 12?
12.
Yeah.
You want to deal with those two next?
Let's try.
The one specific language change he suggested, and I agree with, because it's kind of redundant, is in Section 8, exterior lighting, paragraph B. It starts off when practical. I think we should just get rid of that. It just kind of, I don't know what it means, and I would just eliminate that and start off with exterior lighting except, da-da-da-da.
Okay, so we're on page 25, right?
Mhm.
It's, you there, Nick?
Mhm.
Okay, section 8, do you see where he's talking about?
Yep. Just get rid of that.
So getting rid of when practicable?
Yeah.
Yep.
And in that same paragraph, I noticed when going back and forth between the sign standard and the lighting standard, that the hours of when the lights should be turned off differ by an hour. So, this is 11, in the next line down, 11 PM to 6 AM. The signs is 10 PM to 6 AM. So I would suggest changing the 11 to 10.
Okay, yeah,
You know,
Good.
until you know, I mean, obviously, if somebody's still in business doing their operation, somebody opens up a First Care medical facility and they're open 24/7, then obviously they need to have their lights on, but
right,
even Christie's rolls up the sidewalk at 9 PM.
yep. Yep, indeed.
And the other thing he had suggested we look at a website called darkskies.org,
Yep,
which I did, and curiosity, and that organization's, they actually register lighting fixtures and that are, have hoods on them and stuff like that. And really, the emphasis is just on using downward-facing lighting with hoods on them. So maybe to reflect that, we might want to clarify in A, lighting fixtures must be shielded or hooded and downward-facing. So we don't have somebody coming in with a proposal for basically street lights all over their parking lot. You know, the old style of street lights, I mean.
I love those, yeah.
So, you see where I'm at, Nick?
Mm-hmm.
So after or hooded, add and downward facing.
Did you want to use the word "and"?
Yes,
Okay,
that would be my suggestion.
okay. So shielded or hooded and downward facing,
Right.
okay.
Well, it goes on to say, so it doesn't unnecessarily light the night sky, so,
Right, we do try to be clear
yeah.
with that. I think that's good.
In that same paragraph, the last line,
Yeah, residential.
he had indicated it shouldn't be just limited to residential properties, that's standard. I don't know what to think of that, but I thought I'd just point it out. He suggested that residential be eliminated, so it'd be just abutting properties.
You know, I kind of like that idea, because I don't know if you're gonna bother anybody who's a commercial abutter to another commercial property. But why not be consistent?
Well, and you could, I mean, depending on the kind of business it is, and of course, this is non-residential, so, well, I suppose if a nursing home was built next to a retail sales, I suppose we would consider that probably residential, wouldn't we?
I think so.
But certainly by eliminating residential, that protects, say you have a retail mini mall, and that's developed in year 1, and in year 5, you know, somebody builds a house in the property next door, not a house, but a house 5 years from, well, in year 1, there was nothing there, so the standard doesn't apply.
Right,
What do you do in year 5?
right,
Can't really go back, so.
right.
Yeah, I'm fine with eliminating the word residential, if the rest of
Yeah.
you are.
Yeah, I'm okay with it. Roger?
Yep.
You feel okay with it? So getting rid of that?
Just give it for residential.
Yep.
And then, the other area that he had a lot of comments about was signs, which is section 12,
Right.
and in particular, paragraph B, illuminated signs. And among his comments were a suggestion from some added language. He took issue with the 50-foot candle standard at 100 feet. He thought that was too high. And he also was of the opinion that we should not allow digital signs at all. This is where I like Michael Barrett's suggestion as a sort of compromise. Michael's suggestion, if you recall, was basically to follow the town's lead, and that is restrict digital signs to text only, no pictures, on a solid color background.
That has a lot of merit, I think.
Yeah.
I thought so too, and this got kind of confusing in trying to come up with something for you guys to just, look at. So I actually typed it out.
Wow.
Um,
Because this would be something we could just insert right
Well,
here, I think.
I was just thinking if I was in Nick's shoes and we decided to do something like this, here you go, Roger. So this doesn't reflect all the other changes that were already made. This is just when I cut and pasted, this is the way it came out, and then I added the changes that I was thinking might accommodate or go in the direction of accommodating some of his comments, albeit it's a compromise. So in paragraph 1, that's just a wording thing. It didn't seem to make much sense.
But I had made the same note about not necessarily illuminating the night sky.
Yeah.
From the comments that we had.
So that was his language that he suggested, and I think, that's fine.
Yeah.
And then in 2, tweaking the language regarding the internally lit signs, basically a compromise, not prohibiting them as he was suggesting, but so that it would be shielded or hooded internally lit signs. So if you think about, light from any source, it radiates in 360 degrees, and if it's an externally lit sign, we're requiring it to be onto the sign. Well, on an internally lit, it just spreads everywhere. So if you require, like Steve has next door, you restrict its emission into the atmosphere and onto neighbors' properties by having that little roof thing over it. And so that goes a long way. So that's the suggestion there. And then you can see, that the digital variable message signs be limited to text messages on a solid color background, and otherwise, comply with state law, which is basically it can only change once every 20 minutes. And then it seemed to me it should have the same standard as the lights above.
Yeah, I thought so too.
Or the signs above, rather.
Yeah, agreed.
He took issue with how he thought that 50-foot candles at 100 feet was too high, and I don't know, I can't remember now if he suggested something different.
If he had something else, I didn't have.
Yeah,
it.
no, he didn't. But I don't know much about this, but I was able to find, because foot candles, I don't know what that means in my head, Well, 50-foot candles is the typical lighting in your typical retail store. So, 50, that kind of level of lighting at 100 feet out from a sign, though, along the road, it's in contrast to, for example, dusk is 10-foot candles, typical dusk on a day that doesn't have cloud cover. But it seems like 50 would be okay with maybe, I don't know what to do about places like Depot or Belgrade Lakes Village, because other than I think the shielding from above would mitigate that the best, but I don't know what, 100 feet in the Depot, in some places in the Depot, and certainly most places in Belgrade Lakes Village, that could be two properties over, to have that amount of light. But there's a lot of light down there already. I just don't know how to come to terms with that in that kind of a setting. I was leaning towards, this is what Chris recommended, deferring to Chris on that, but, if we changed it, I wouldn't know what to change it to.
not being a,
Lighting expert?
right, at all,
Right.
and I would say, let's stick with what Chris had to say. I did see a note in there when, Mac had talked about, some type of, internally lit signs, he had a note in there about, they're designed to attract attention, and then he went on to say how that could be considered unsafe. Now, while I agree with that idea, I don't know how adjusting or changing what Chris has recommended for foot candle power for the
Right.
intensity would.
And I think, with those digital signs, what's, the bigger problem is the
Frequency.
frequency with which they change.
Exactly right, because if, the reason why we know this a little bit is that we had, the fellow, he has a sign company in Lewiston, he lives in Belgrade, he was here at the hearing. He came into the planning board one time, we asked him to talk about internally lit signs, and he,
It's Christie, he had something to do with Christie's.
yep, exactly, and, I don't know if I can put my hand on it, but at any rate, the point is,
Yeah, he had given us
Neocraft.
paperwork on it.
yeah, Neocraft signs. And they talk about speed and viewing distance and all that type of stuff, so, for a driver, having a digitally lit sign in view when driving at a certain rate of speed, at a certain rate, the frequency that it changes and your amount of time distracted from the road,
Yeah.
that changes.
Yeah, he said he worked with the state on that, on getting how it should be and all that stuff.
Yeah,
Mhm.
so the letter visibility, the letter height, readable distance for maximum impact, all those things are all charted out in something that he provided to us before.
Do you know the problem they don't say with that is when they change them too often, like the message boards on the turnpike,
Yeah,
if it's got 3 or 4 lines, it's not on long enough for you to read all 4 lines, so you're gonna keep staring at it till it comes around again.
Yeah,
yeah.
right, I've noticed that with advertising
Yeah.
signs, same thing,
Yeah.
right about that, right. Anyway, that was my suggestion for how to,
I think that's
a
great.
compromise
Yeah, that
and
is, yeah.
accommodating his, at least the spirit of his.
I had a question, Roger, you might have one too, I don't know, but, about the solid color background part, 'cause
I like that. I mean, this is a good example. If they wanna know what we're talking about, I mean, you just come by here at night, and look at it. It's soft on the eyes,
it is, it is.
and it's not that bright, but you can read it from far.
Mhm.
Yeah, I kinda like it.
So, and I'm not trying to be a wise guy, if I choose to have a solid color neon green with black text, is that fine?
It's a solid, it's a,
I just wanna make sure,
Yeah.
Yeah,
'cause
I
someone
mean,
may,
Somerset Stone oftentimes has really bright green on their side.
Yes.
Theirs is flashing all the time
Yeah.
and doing all kinds of funky stuff going.
yeah,
yeah.
yeah. So, just as long as we're clear,
Yeah.
then when we're saying this, that a solid color could be any solid color,
Yeah, it could be
not
any
just
color.
black.
Could be international orange, it could,
Right, so as long as we're okay with that, then I think this is fine.
yeah, I think it becomes a question of how prescriptive do you wanna be.
Right, and I would prefer not to be too prescriptive,
It's not a, I call that a carnival sign.
Right, yeah.
so, okay, thank you. Let's see, I think, were there other comments that we had to go over?
There's one other place where, one other page where,
Oh, it has,
oh,
the overnight accommodations?
yeah. But I also had a couple more places where
Oh, cell phone tower.
footprint area probably should be, added, but, I could always, send those to Nick if we're okay with the concept of that, but you're right, there was, some language that he suggested we eliminate as being redundant is that Article 8 or?
Let's see. I'm just looking for a place where I use my red pen. I'm in Article 7.
Article
says
7, right.
Development standards for specific activities. Section 2,
Right.
overnight accommodations. I had a question mark by, so section 2, B, 2.
Right. His comment was, why do we care about requiring 2 spaces be provided for the owner of the business?
I thought that was a good question.
Yeah, and, I don't, that seems unnecessary to me.
Right, right. So I'd be happy to strike that. So in other words, in developing a parcel for an overnight accommodation business, bed and breakfast, for example, is it in the town's best interest to prescribe that the owners have 2 parking lots and have that outlined in the ordinance? I guess after I thought about it, I'm like, I don't know why we would have to do that.
Yeah,
But maybe it protects the
I suppose it's coming from the point of view of ensuring that there's enough parking spaces, not just for the clientele, but, that whoever's developing it takes into account, and that we take into account the fact that the owners are gonna need parking too.
Yep. Let me give you an example of where that might come into play, possibly. In a in a land constrained area, like down in the village, say that the Saxton house, say if someone bought that and said, oh, I'm gonna turn that into a bed and breakfast with 3 bedrooms, so that means, okay, 3 parking areas, 1 per guest. Now, what about the owners, where do they park?
Right.
Now, this might be how this came to pass, in that the thought process was in a
Yeah.
resource constrained area.
Yeah, right, that's a good perspective to take, because it's, if somebody builds a B&B out in the West Road, that's easy.
Use your
But down in the
space.
village, that's hard.
You've
So
been
maybe
by
we should
Pesci
just leave it
House?
well.
In Oakland?
Yeah.
Yes,
How many
Maybe we should-
parking spots they got?
I don't know.
They got room for 4 in the driveway, and that's it.
Yeah. So it is-
Now, we haven't stayed at B&Bs often, but we once stayed at one in Bethel, and we had to park on the road.
Mm.
Maybe we should just leave it alone.
Does it
Yeah, I
hurt
would.
does it hurt to leave it alone?
Probably not.
You okay,
What do you
Raj?
think, Roger?
I'd rather leave it the way it is.
Okay,
Okay.
I'm okay with it. I mean,
When what's-her-name had it up by my house, they got kicked in, and she had to put in parking below it and leave the regular driveway, which was for 2 cars. So the guests parked down below, and she parked up above. And her come in the morning and parked up above. So,
Okay, so, sounds like it's justified.
yeah, we can leave it.
Yeah. There was another thing that, in that same article that he mentioned, that I do think needs to be added. He made the point of, that there's no standard for the proper abandonment of a out-of-use wind energy tower, as there is for telecommunication towers. So, somebody builds a wind tower, commercial wind tower, not, private residence, but a commercial one, and they go, bankrupt, or whatever bad happens, and, the federal subsidies dry up, and so they're not making money, and they go out of business, or whatever. There's nothing in here that requires them to properly abandon that tower once it's, the business is defunct. So there it sits, potentially becoming a safety hazard.
Yep.
So, so this would be in, section 4 of that same article, wind energy facilities. And what I would suggest is adding basically the same language that's under telecommunication towers to it, and I actually, it's on two little yellow stickies, but why don't I, so it'd be like E, it would be a new paragraph E. Let me just read it, and then you guys can tell me what you think. So it'd be E, proper abandonment. The wind energy tower that is unused or out of service for a period of 18 continuous months shall be considered abandoned and shall be removed as soon as practical. The town of Belgrade is hereby authorized to contract for the proper removal of a tower and assess the cost of the removal as a lien against the property. And that's, you may recall Michael Barrett asked a question about this.
Yes, yeah. And that's the same language we have, where is that?
And
We
so that's the same language as in section 3(6).
Perfect. 'Cause I was really concerned about making sure we have the lien part in there.
Right.
Because as long as we have basically one throat to choke, someplace to go.
Because in a case like that, let's say like Florida Power comes up and buys them and just wants them off the grid, just shuts them off.
Oh,
Right, for business.
Like
Oh,
they've been
good
doing
point.
with a lot of dams.
oh, good, good.
Yeah, hell of a
point.
point, yeah.
Yep.
You
Right,
know, if
might
they don't
do
run
it.
them for 18 months, they're abandoned, take them down.
And the cost goes to
Yeah.
that owner.
Yeah.
Yeah.
Because that happened in Island Falls. A company come up, bought the dam, they told the town they're gonna keep running it, they shut it right down, left everything right there. Every year it flooded.
Why don't you pass these down to Nick, although it's the same language, would we, you know, you probably could copy and paste it.
From-
Okay.
I'm glad Michael brought that up, and George, thank you so much for pointing that out.
The only other
But
thing
the-
that,
The thing about wind power is you can tell if they're not using it, because if you go a year and a half, you don't see the blade turns, you know it's off. But communication towers, you can't tell,
yeah, that's right, you can't.
so.
Yes, was there another?
Well, then there's a series of more minor things that Mac had suggested. Before I get to that, he had made a big issue out of wanting a public hearing rather than
Mhm.
us taking these up as part of our normal meetings and advertising them. I think it's, you know, 6 of one, half a dozen the other. I think it's more efficient for us to do it in the course of our normal hearing. The fact that we're gonna be advertising it far more than it's ever been before will provide the public with the opportunity to participate if they so choose.
Yeah, because this is a public meeting.
Right. I guess I disagree, you know, with what he was suggesting.
The only thing about having it on a weekend is there's a lot of people that work that wouldn't go to a meeting, you know, like on a Thursday, but would probably show up on a weekend. Not that we've had that many turn out, but.
Right. I heard his concerns, you know, and, you know, he pointed out the fact that he read something that had the word hearing, and that got his attention. I think that's was the exact word he said.
Right, yeah.
That's why I'm here, because I read something that said hearing, and to him, that meant something. So, I hear his concern on that. I'm not convinced that we need to alter anything.
Yeah. And then the other thing that he brought up, and it's found in a variety of places, primarily in Article 4, where there are different timelines for when either we or Gary have to accomplish something, review something. And in all cases, it just says X number of days.
Right.
And he thought they were all too short, and we had talked about, and he seemed to agree with this, clarifying that they are business days.
Yes. Yeah.
So, Um, The first, two of the places, so this would be section 5, application procedure. 5.2, under code enforcement officer review, paragraph B. Actually, that's 5 working days in the second line of that.
Change that from working to business?
Yeah, business days, that's pretty standard language, at least that I'm familiar with. Let's put it this way, it's standard in DEP regulations, let's put, whether that's any reason to.
Can we say the same thing for, the next paragraph down, C? It says,
Yes, yeah, where it says 10 days now, 10 business days.
yeah, I'm reading,
Oh, working days,
15
I'm in
working
C,
days.
I'm sorry, I'm
yeah,
at a different C, yes.
so 5, but no more than 15, change from working to business.
Right,
And then I think you're at 5.3B, George? For
correct.
10 business days.
right.
You see that down there? So 5B. So probably a search of that area to look for working, to see where it could be applied and changed to business.
The next, there's a whole series of them under section 6, which is planning board review. Six point one, timing of review, 660 business days.
So
Then
6-1,
in-
got that, Nick?
Instead of 60 days, put 60 business days?
Yeah. Then notice of meeting requirements, 6.2, A1, 1, 2, 3, 4, 5 lines down, it says 7 days, 7 business days. And then, next page, paragraph 4, again, 1, 2, 3 lines down. There's, 7 days, 7 business days. I think that's all I found.
You find that okay? One quick thing, we're in the area, I made a note, this is on page 11, so it's under section 6, 62A1, where that reads, all abutters and all other landowners within 500 feet of the lot upon which the project is proposed, that thing.
Mm-hmm.
I wrote here that the person totally disagrees with that.
Right.
And so I hear what he's saying about it, but I guess I would wanna make sure, just cause I feel one way, doesn't mean much, but how does the board feel?
What page are you
I'm on page 11, so it's under section 6, 62A1. Oh, yeah, and you marked it too.
Hmm.
So all about it, so Mac had totally disagreed with this whole thing.
Yeah, no, this goes back to him preferring the public hearing that this replaces.
Yeah.
I just don't see much difference myself.
Okay, let's go back one more. Seeing as how we changed the other regular days to business days on the 6-3 decisions, the code
6-3.
enforcement officer within 7 working days, you wanna change that to business too?
Oh, good catch, yes.
Yeah, oh, good one. So, I guess I'm still not of the opinion to change everything.
Nor am I.
Okay.
Planning board requirements, about, just before decision, that C above it,
Where are we?
on page 12. The board may continue its deliberation for any further time and location, subject to posting requirements and 60-day review limitation. You're gonna leave that alone?
Oh, we probably want that to be business days, don't we?
Yeah, I think so. I mean, the fact of the matter is, you know, counting weekends doesn't serve anybody particularly well.
Right. Let's try it.
Last thing I had to do with footprint area, another area in the ordinance where footprint area needs to be dealt with.
Oh, yeah? Where is that?
It is, see, it's article, it's in the standards, it's in Article 6. It's the stormwater section, which is 13, section 13. And it's, in paragraph B. First line, 7,500 square feet in footprint area, and then third line down, exceeds 30,000 square feet, again, in footprint area.
What page you on?
Well, my page numbering is, I think it's either 38 or 37 on yours. So, section 13B.
Section 13. Hang on. 13B. What, does it read, for any development which will exceed blah, blah, blah?
Correct.
So, on mine is page 34.
Ooh.
That's okay. So, I think, yep, I think that's it right there, right? So, yeah, so here we talk about square feet of impervious surface? Oh, okay. So, George, what are you thinking?
Just adding, in footprint area after square feet,
Okay.
and likewise on the third line.
I guess I'd recommend that maybe do a search for anytime you find square feet.
Put
And
in footprint area after it.
I think so. Does that make sense, you guys? If we find,
Yeah.
you know, something square feet, to look and make sure that it says after that, how do we say it?
In footprint area.
In footprint area, yep. Okay. Anything else?
This has nothing to do with, Mac's comments or Dick's, but I found, a minor, somewhat minor error, in, section 9 of, article, it's probably 4. Yeah, no, yeah, Article 4. Lost my page, oh, there we are. Section 9. Revisions to an approved plan. 9.1, the third bullet down reads, an increase in storage capacity or use of toxic, flammable, or hazardous substances. After flammable, we need to add combustible. Flammable would capture gasoline, but it doesn't capture heating oils, which are combustible.
So we would say toxic, comma, space, flammable, comma, space, combustible,
Correct.
comma, space, or hazardous stuff.
Mhm.
Does that make sense?
That way, if somebody has a business and they're gonna add, say Christie's decides they're gonna start, not Christie's, somebody that's already gotten approval adds, say a new gas station in town, and they decide they're gonna go into the bulk heating oil business, and they start putting bulk heating oil, they want to add that, this captures it.
Yeah.
Yeah, we got 3 more places in here where it's got 35 days and 45 days and 30 days. D up at the top, the
Yep.
Board of Appeals.
We wanna say business days, I believe.
Then under F, same thing, and then G.
Maybe that would be something, you know, I did it, my stupid computer at home doesn't have a search tool on it,
That's too bad.
and, well, it's a 2006 computer, and
Yeah.
we're getting warnings all the time that, you know, our search engine isn't being supported anymore, so we gotta buy something new. I can't even upgrade, I tried to upgrade it with Microsoft, but anyway, that's a whole different can of worms and story, but, maybe another word search.
Yeah,
Same thing.
yeah, please. So look for days, and just make sure that it makes sense that it says business days.
Well, while I'm at it, I might as well go in the back and see if it, definition of days.
I don't know.
Days mean business days.
Yeah,
According to the, which calendar?
if not, maybe we should put in something in the back.
I don't see a definition of days or.
No, it's, again, that's one of those ubiquitous things, I mean,
Or business days. But that is pretty standard language in most things. The only other thing I could recall, Rich Baker said, I mean, he's not here, but that he had some typos he'd found.
Yeah. Like Sahagan Road, I think was mentioned in past.
Oh, was that one of them?
Yep,
We've only changed that about 3 or 4 times now, haven't we?
I think so.
More than that, I think.
Yeah, things like that, and I think I would also wanna point out, any, font inconsistencies, to look for those, please. Pagination, numeration, any of the stuff that happens when you start having things glommed together, you know, because Word tries to think for you and, you know, rearrange things sometimes, you know, it's a little. So please double check all the, like, how things are numbered and lettered, and that it makes sense. Put your most critical editorial eye on it.
Will do.
Okay, thanks.
Man, we're breaking you in on time, aren't we?
Yeah.
I know. I you know, I wanna thank everybody for their efforts. Thank you very much. Thank you all for putting forth such a thoughtful.
God, who's ever thought we'd be at this point, huh?
I know. Well, I have high hopes that we would be at this point.
Yeah, me too.
I continue to hope, you know.
It always seemed elusive.
I know.
Let's hope the next one's better.
Yeah, I know.
Oh,
All right.
Can't be any worse.
I
Under this table.
I was gonna suggest that we table the minutes. Is that okay?
Yeah.
Yes.
I hate to do it, but at the same
Yeah.
time, I feel I must. I'm
We,
fried myself and.
whether it's next meeting or, maybe we just need to, really.
Yeah, the other guy should be
Leave enough
involved
time
in
for
it, too.
doing that, because we got a host of them now.
We do. We need to get them done.
Yeah, we do.
But the other guy should be involved in it too.
Yep. Agreed.
Yeah, good point. When does Peter Sargent come back?
Probably like a month and a half from now.
From now?
For a while.
So it took 2 months ago, a couple weeks ago, he gave us 2 months worth of meetings. First one was 2 weeks ago.
Okay. Could you give that to Rich, please? This is all.
Dylan Pete got
Scrap
stranded last
paper.
Thursday, wasn't a good time for me. I got stranded with my truck, cost me over $1,000. Following day, same damn
We're
thing happened
done.
again, so I had to go back
Yeah,
in.
meeting adjourned. 9.
Sunday, taking my camper up to my son's, I blew a tire, got over $1,000 damage on the side of the camper.
Oh, so he hit it?
Well, the tire took the siding off and the trim.